The superposition of national legal regimes in maritime disputed areas. Superposition of national legal regimes in maritime disputed areas is governed by a set of international rules provided for in Article 74 and 83 of the United Nations Convention on the Law of the Sea or UNCLOS. According to those articles, and as the international jurisprudence confirmed, not all activities are permissible in those areas, and claimant states are bound by a general obligation of restraint that, at the very least, imposes a duty not to permanently harm the marine environment. States are also required to negotiate in good faith provisional arrangement of a practical nature aiming to limit conflicting national legislation and conflicting activities. In the absence of provisional arrangement, the legality of state activities in an area of overlapping maritime claims isn't clear. This paper reviews in the light of the international jurisprudence and state practice the regime devoted to disputed maritime areas. It then highlights the main features of the obligation of self-restraint in a context where each state is trying to assert its sovereignty and maximize the benefit of its claim over a maritime disputed area. Significant part of the sea remain undelimited, which raises tension when several states may be deemed to have jurisdiction and therefore be entitled to exercise their powers over the same maritime spaces. This phenomenon appears even more prominent in a context where the interests of states for the blue economy are growing, which increases competition for maritime space and the probability of conflicting uses of the sea and calls for more diplomatic dialogue and cooperation. Maritime disputed area or MDA are commonly defined as areas where the claim for two or several states of a specific maritime zone, in general the Exclusive Economic Zone or EEZ or the continental shelf overlap and no final delimitation, whether by agreement or judicial award, has been reached. An MDA is, then, an area where two different states or more advance a plausible legal entitlement and indicate, in their respective views, what the correct delimitation line should be, whether by formal claim at the international level or by their national practice. In this context, on the one hand, an MDA is the typical area of superposition of national legislation emanating from both states. On the other hand, superposition of national legal regimes is the consequence as well as the empirical evidence of an existing MDA. According to customary international law and specific provision of the United Nations Convention on the Law of the Sea or UNCLOS, states with opposite or adjacent coasts shall reach agreement for the delimitation of their EEZ, Article 74.1, or continental shelf, Article 83.1. There is no such a provision concerning the territorial sea, but according to Article 15, if two states have opposite or adjacent coasts, they shall not extend it beyond a median line, except where they can found their claim on historic title or special circumstances. Besides, even for the delimitation of their territorial sea, states are bound by a general duty to cooperate and to act in good faith. Article 300 UNCLOS. When studying MDA, scholars focus in general on the EEZ and continental shelf because of the specific provision of Article 74 and 83 UNCLOS. Indeed, both articles include a provisional regime in the case where no final agreement been reached. In such a situation, Article 74.3 and 83.3 provide that the state concerned, in the spirit of understanding and cooperation, shall make every effort to enter into provisional arrangement of a practical nature and during this transitional period, not to jeopardize or hamper the reaching of the final agreement. Such arrangement shall be without prejudice to the final delimitation. The exact meaning and the scope of such a provision remains unclear. Yet, the issues and interests at stake can be tremendous. On the one side, it recognizes a de facto transitional period during which overlapping claim as well as the national legal regime of state are supposed to coexist. The provisional regime provided for in Article 74.3 and 83.3 UNCLOS may therefore limit the probability of conflicting legislation and practice at sea. On the other side, practice shows that the existence of a disputed area and the lack of cooperation between the claimant state can lead to the unilateral enforcement of national law. This can impact navigation, the exploration and exploitation of marine resources, the protection of the marine environment, or even lead to the search and seizure of vessel or crew detention. In such a situation, the coexistence of several nation legal regimes create a presumed balance of power between the claimant state, which are each pursuing effectivity. States will try to maximize the scope of their jurisdiction and powers in the disputed area and hope for validation of their unilateral practice after an extended period. It is even more the case when the delimitation dispute is linked to a sovereignty dispute. However, according to the provisional regime established by Article 74.3 and 83.3 UNCLOS, the claimant states are bound by a general duty of restraint in an MDA, an obligation to make every effort to enter into provisional arrangement of a practical nature and an obligation not to jeopardize or hamper the reaching of a final agreement. It is therefore important to identify what state can or cannot do in an MDA. The interpretation of those provisions implies the determination of the existence and the substance of an international legal framework limiting the respective powers of the claimant state in an MDA. It also raises the question of the opposability of the unilateral practice to one claimant state to the other, as well as the question of the entitlement of one claimant state to react to the unilateral practice of the other. To that extent, it is interesting to shed some light on the interaction between superposition of national legal regime and the provisional regime applicable to MDA. Section 2 of this article focuses on the effect of superposition of national legal regime in MDA from the perspective of the international law of the sea and the provisional regime provided for in Article 74.3 and 83.3 UNCLOS. Section 3 presents the various response of state to the superposition of national legal regimes in MDA. The effect on the superposition of state legal regimes in MDA. The superposition of the national legal regime of two or more states which have plausible entitlement to extend their jurisdiction over a maritime zone can be seen as both a cause and a consequence of the existence of an MDA. Firstly, superposition leads to the identification of a disputed areas. Indeed, it contributes to the precise determination of the area covered by states' overlapping claim. Subsection 2.1. Secondly, since a maritime zone appears disputed between two states which both consider they have jurisdiction, a situation of superposition of national legal regime ensues. Subsection 2.2. Thank you.